Welcome to the Week 5, Chapter 5 video lecture. In this chapter, we're going to be dealing with dynamics of courthouse justice. We'll actually get into the courthouse and do a good, thorough investigation of what goes on in there, and who's involved in it, and how they operate, some of the formal and informal rules that people work by, and so on. So if we look at the learning objectives we have for this particular chapter, first we're going to have a general sense of who works in the courthouse, where they work, and how they work. Then number two, we're going to analyze the importance of assembly line justice, and we'll see how important that is because of the massive caseloads. Even in the criminal world, civil world is even more massive, but the criminal one by itself is sufficient to make it essentially required that we put it in an assembly line kind of a justice situation because we need efficiency in order to get control of this huge caseload. Number three, we're going to deal with describing why discretion is found in the criminal courts, and we'll tell you where discretion is found, why it's there, and how it's exercised. And then we're going to, number four is identify the principal actors in the courtroom work group. And by courtroom work group, we mean the judges, prosecutors, defense attorneys. They are the courtroom work group. They get together for the purpose of trying to essentially deal out as many cases as they can. If you really want to know, that's exactly what they're doing. They're trying to get as many cases to resolve without a trial as possible, and they've been largely successful with about 95% of cases being resolved through plea negotiations rather than through a trial. If it were not for that, by the way, the entire court system would fall on its face tomorrow, because we simply cannot try all those cases. In fact, I actually had a situation that came up when I was first a prosecutor, and there were 12 cases on the docket for a 5-day week. They were all in the hands of the public defender. These were all DUI cases, by the way, and they were all in the same justice court. They all were time barred. That means they had to all be tried within that week, or they would have to be dismissed by law. And the public defender decided that she was going to sort of play a game of getting all the clients to agree that they were all going to demand their right to a trial so that some of them would get out of their cases. And they all agreed to do that. So there's nothing wrong with doing that, but it presented a serious problem, as you might imagine. Well, me and the judge got together, because I was the prosecutor, and we said we're gonna try it 3 of them every day until we get them all done. We literally picked 3 juries in the morning. We had one of them come back at noon, one of them come back at 5. We tried 3 DUIs the first day. They were all guilty. Came back the second day, did the same, picked 3 juries in the morning. Did the first 2 cases, they all came back guilty, and then the public defender got tired and decided that she was going to talk her clients into waiving time to have the trials done later. We had 5 trials in about a day and a half. We were going until midnight, by the way, on these days, but we were not going to let them get away with it. But that just shows you how the system would break down if we didn't plead out these cases, and about 95% of them, because we just don't have the courtroom space to try them all. Okay. All right. So we're also going to number 5. We're going to indicate why ethics are important in the American legal system. We'll see how important that is and why they're not always followed, and how that really makes the system look bad. Number 6, we're going to contrast differing understandings of why delay is a problem in the courts. And it depends on how important it is to people involved. But we think of speedy justice as being important in many different ways. But the delay that we see is often quite understandable, and we'll see the reasons why. But it is something that just it grades on people that that there's so much delay in the courts, especially for the witnesses and the victims of the cases. They don't like that. However, judges are more than accommodating to this delay, because delaying a case just means they don't have to try it now. They can try it later, They put everything into the future because they have so much to do now. Number 7, we're going to discuss the strengths and weaknesses of the speedy trial laws. There's good and bad to all this, you know, and if you remember the O.J. criminal case, the defense made one very smart move, and that is they insisted on their speedy trial rights, and the prosecution was just simply not ready in the time that they had to go to trial. In fact, the only reason why they were never ready in the first place was because of that big ride on the freeway that you probably saw on national television, where the cops were following O.J. because he was on his way out of town, trying to get out of town before he was arrested. And they just simply had to deal with the case then because otherwise he was going to take off and we'd probably never see him again. And so they had to try the case then, and they were not ready. All right, number 8, we're going to explain why law in action approaches to court delay are more effective than the law on the books approaches. And we'll see that we really have to sometimes just be very practical about how to deal with all of the stuff that's going on rather than having to do everything by the book, okay? All right, let's look at the courthouse. First, location, buildings, and players. Location, courthouse are usually set in the middle of government buildings, usually in the center of town somewhere in a downtown area. That's because that's where things are going on. They're often next to or very close to police stations because that's where people are held in custody often. They're usually located near a jail if that's possible. Depends on the location. But they're in the middle of the thoroughfare, basically. It's you know, downtown type of situations. The buildings themselves usually are very palatial in nature, generally, although some of them look kind of old and you know, boxy for the buildings. If you go inside and you look at the courthouse itself, the actual court, not the courthouse, but the courtroom, then they get very, very ornate and very, you know, almost intimidating in terms of the accoutrements that you have in there. You typically have you know, mahogany wood paneling on the walls, and this big huge bench where a judge sits up there with his robe, or his or her robe. It looks like, you know, some sort of king sitting there, you know, guiding the entire process. And then, of course, the players, many different players. You have the judge, of course. You have the court clerk or clerks. Sometimes there's more than one. You have the court bailiff. You have maybe more than one bailiff, depending on how much security they need in the courtroom. You will have the plaintiff's lawyer and maybe someone with the plaintiff, and in that case would be the prosecution, often with their investigating officer there if there's going to be a trial. The defense attorney and the defendant are there, and sometimes there are a number of defendants. They're seated in the jury box while we're calling their cases in a typical calendar call before there's a trial. Later the jurors will sit there, but until then they put the in-custody defendants in the jury box, handcuffed, of course. And then you have the let's see, some bailiffs that might be outside the courtroom next to the doors that lead into the courtroom. You may have members of the public there. You may have bail agents. You may have a number of you know, drug rehabilitation people there who are bringing their people in for court appearances. There can be just a wide group of people who have something to do with the matters that are on calendar for that day in the courthouse and the courtroom. They're all there, and then of course members of the public, possibly the news media if it's a big case for some reason. All right, let's look at there's the judge's bench. Let's look at that. Visitor access just means that people can come in and look at any public trial as long as there's room. They can come in and sit down, and that's because we do not allow the government to have closed trials in criminal matters because we don't want them railroading people. So it's our way of making sure that the government's doing things the way it should. We have witnesses that are there to make sure they're going to do it the way they should. The judge's bench is usually a very tall bench that is very ornate, and the judge, of course, sits up there with this big black robe and looks all majestic for good reason, by the way. You think this is for some eagle thing, but it really isn't. It's actually as a way of engendering respect for the court's decisions, because someone's going to lose and someone's going to win. And we want the person who loses to say, you know, I don't like that decision, but I'm going to have to respect it because the judge has the power. We don't want them questioning the judge, ever. That's not going to be allowed. And so we give this impression, visual impression, that the judge is all-powerful. And that, to a large extent, that's true. There's also the defense and prosecution. These are attorneys that will be at the counsel table. That's right before the judge's bench. We will have the jury itself, which is in the jury box. That usually has anywhere from 12 to 18 seats in there for the jury, and the alternates that are all there watching the trial. Of course, we have the defendant, who's also at the counsel table with the defense attorney. We have deputies that usually are at least in the front of the courthouse, the courtroom, next to the judge's bench to protect the judge, believe it or not, and anyone else in the courtroom. But then typically you'll have at least one of them in the back next to the door, preventing the defendant from running out the door, and also watching the people in the audience to make sure there aren't people in the audience, you know, picking up a gun and starting shooting people, because that has happened. Okay, if you actually look at the diagram here on the PowerPoint, we typically have the plaintiff's table, defendant's table. The plaintiff's table is always next to the jury. That has to do with the fact that the plaintiff has the burden of proof, so they're given the best seat, so to speak, next to the jury. Defendant's table is away from the jury. The clerk table could be out in front, as we see in the judge's bench, although often it's actually over by the defendant's table, sort of out of the way. Certainly we have the witness stand here and the court reporter, although we typically see in California, this court reporter will actually be to the left of the witness stand, so that they can hear and see and watch the witness as they're testifying, to get so they can actually see, because sometimes a witness might shake their head or nod their head as a response, and the court reporter has to actually put that down in the transcript that there was a nod of the head, because it's a response. They can't see it if they're on the right-hand side of the judge. Of course, here's the judge's bench. Judges' chambers are right behind them, so they can walk right through this door and get out. That's also for security purposes. You see the bailiff over here to the right of the judge. That bailiff typically, in my experience, has been actually out here to the right of the judge, but in front of the judge's bench. That way, the bailiff can then provide security for the entire courtroom in front of them, in essence, get in the way of anything that comes towards the judge, including sometimes defendants. You may have actually had some knowledge of some of the cases in California where defendants literally have jumped over the table and jumped up on the judge's benches trying to get to the judge in the middle of the trial. It's actually happened. Here's the jury room door. The jury will recess and retire at different times during the process of the case, and so we'll have them walk out of the jury room and right down to the jury in this jury room, where they'll shut the door and they're kept away from other people, so there's no talking between people and the jury. Okay. All right. Let's look at some of the courthouse actors. Of course, the court security staff, that they provide security throughout the courthouse. In fact, they're all over the place. Every courthouse typically has a very good video surveillance system, and there are people within the courthouse who are watching that system and dispensing security people as necessary as they see things developing in courtrooms. And the sheriff's deputies will transport prisoners to and from jail, and they will keep them in the courthouse, in the courtroom, and they'll be right next to them, even though they're handcuffed. You have a security person right next to them. We do not want them running up and trying to hurt anybody in the courtroom, including the judge. The bailiff then simply maintains order in the courtroom. The bailiff will tell you, it's my courtroom. I'm the one that tells you what you can do and what you can't. You violate my orders, and I'll either throw you out or I will arrest you for contempt of court. They also handle the evidence so that it's not put in a position where we wonder who in the world would have their hands on it. We have someone who's a believable person who takes in the evidence from both parties and secures it. All right, let's look at some of the other actors. The judge, that's the officer who presides over the case, and as you can look upon the judge as basically being a referee over the contest. unless the judge is going to make the decision in the case, which is not always the case. Often in criminal matters, it is a jury that makes the decision, but both sides can waive the right to a jury, and the judge will hear the case. And if that's the case, then they do more than just refereeing. They will actually be deciding the case. There are law clerks, sometimes known as court attorneys, that will perform legal research for judges. They may be out watching the court calendar being called because maybe there's something that they need to tell the judge at different times, or they just want to see what the arguments are that are out there. And then we also have the clerk of the court. They keep records of everything that's going on. They summon the jury. They swear in the jury. They do very, very specific functions. They will log in and tag the evidence and keep it, secure it for the court. The court reporter, of course, takes verbatim transcripts of the proceedings. The secretary handles routine work of the judge's office. That secretary may or may not be out in the courtroom. Typically, they are not. They are usually back in the judge's chambers area behind the judge. There's the translator. If translation is needed, they will be there in the text, and they'll render translations of what's going on in the courtroom for whoever needs the translator. Usually it's a defendant, but could also be for witnesses. The court administrator, that's a person usually you never see. They are the ones responsible for actually running the courthouse itself. They supervise and perform administrative tasks for the court. In fact, there's actually degrees in court administration that you can get because it's very, very specialized kind of work. Next is the docket clerk. This is the one that prepares case files, distributes legal documents to attorneys and judges, and maintains the records. They may or may not be there. Typically, we'll see them in the back somewhere. They're not necessary to have out in the courtroom. Then there's a probation officer. If the probation officer is needed in the courtroom at a specific time, the probation officer will be there. They will often be seated next to the prosecutor. They recommend defendants for probation or monitor their activities while on probation, but they sometimes will be there at sentencing because they have a sentencing report that they give to the judge, and they need to be there to answer questions. Then there's a pretrial services representative. What pretrial services have to do with when in custody defendants come into the system. Pretrial services will do a background on them to see what is the appropriate amount of bail for them, and will then give a report to the judge on what they have found. So we don't typically find them in the courtroom. They're really generally not needed. The report is already there by the time the in-custody defendant is there, and the judge needs to make a decision on bail. There's diversion program representatives. They will come in if there's a calendar call where diversion might be given to someone, and so they will go through and either recommend diversion programs such as drug rehabilitation or anger management as a way to divert people from going through the criminal process. And what happens is if they go through the diversion program and they complete it successfully, they will have their criminal cases dismissed. It's a very, very good incentive program. They usually only allow it for first-time offenders, and they won't allow it a second time, at least not for the anger management type where we have violent things, especially domestic violence. You will have your bail agents. They will often be usually in the audience. They're actually watching to make sure that the person they have bail on is actually showing up. Because if they're not, they're going to go immediately out to try and find them, because they're the ones that are going to have their bail forfeited, and they don't like that. And so they'll actually bring the person in themselves often to make sure that they come in. There's the reporter. They provide media coverage of key events if they are there. They will typically also be in the audience. The defendant, of course, that's the person accused of violating the law and is the defendant in the case. They will be up at the counsel table with the defense attorney. Your victim, that's the person who suffered the loss due to the crime. They will typically only be coming into the courtroom during a trial, but they can come in at sentencing if they have a right to speak at sentencing, and in California they do. And so they would be in the audience and then asked to come up and speak to the court at the time of sentencing, just to get their opinion about what should be done with the defendant. There are witnesses. They will typically not be in the courtroom until and unless they are testifying. We do not want them hearing what's going on and being influenced by what is being said in the court. We want them to be basically out there, unfettered by any words they might hear about the case. We want to hear what they say, but without any interference. Then the jurors, these citizens, these are just basic citizens who come in and they will decide the case. They're picked through a process, the voir dire process it's called, which just simply says, there is a Latin phrase, to tell the truth. Basically, we inquire of these people to see if they can be fair in the case, and we only allow people on who can be fair. All right, you may have a rape crisis center representative. It's possible, especially if there's a victim who has a right to be in the courtroom at a particular time. You'll have the rape crisis center representative if it's a rape crime. You'll have a child advocate if the same is going on as to a child who might be a victim in a case. Possibly if the child is a witness in the case, but more likely it's a child victim. And then there's court watchers. These are people who go to court to observe proceedings. These are just citizens who just want to see what's going on. You'll see them in the courtroom from time to time. And then there's the victim witness assistance people. These are people whose job it is to assist victims and witnesses in making their appearances in court, and sometimes they're even allowed to walk up to the witness box with them and hold their hand, basically, because it's often a very stressful event for victims especially, but sometimes even for witnesses. All right, so courthouse managers. First we have the clerks of the court. We have notaries, we have they have many duties to do, but they basically keep records. Essentially, they're like a clerk in that sense. They keep records. We have chief judges who may not actually be out in a particular courtroom at a particular time, but they're helping with the court administrators to keep things moving through the process. And then we have the court administrators, of course. These are all manager types who manage all the stuff that needs to be done. And again, chief justices or chief judges, they decide what judges do what kind of cases. They divide up all the work among the judges. They make sure everything is going efficiently. They do not want to see a department going dark, as they say, which is where we can't try a case in that trial court because all the cases that were set for that day have somehow resolved. We'll find a case for you. We do not want a case or a courtroom going dark, so that we lose a day of court time on trials. We have too many trials for that to happen, so we have to have that kind of management. Now, security and changing technology. We know that courtrooms are the targets of violence and have been in the past. Now, interestingly, if you actually look at the statistics, and judges will tell you this, the violence in the courtroom is not so much in criminal cases. Yes, it happens, and yes, there are good reasons why it happens. Sometimes people are just trying to escape. It could be just that, but sometimes other people who don't like what's gone on and want to dispense justice themselves, for instance. But your biggest targeted acts of violence in courts actually come in family law matters, not criminal matters. I know that sounds odd, but it's true. If you take someone's kids away from them, which you could do in family law courts, and take away their parental rights, they may want to kill somebody. You know, you get somebody who's a drug dealer, sort of know they're going to go to prison from time to time because that's the price of admission in that industry. Well, they sort of, take it in stride. And yes, they are upset, but they're not going to kill somebody over it typically. And even if they thought they would, there's plenty of security out there for it. And so we'll see, by the way, metal detectors, surveillance cameras, all over the place in every courtroom that there is because of that problem. And there's even security beyond the courthouse itself. We've actually, for certain types of cases where there's some threats of violence, usually gang cases, we actually have security people on the roof of the courthouse ready to start shooting. These are like snipers ready to start shooting if gang people come in the area to try to break things up. It has actually happened, even in a small community like that I have in Central California. All right, let's look at the Brian Nichols case. The Brian Nichols case was very famous for someone who was known for escaping, and this is not back in 1971, by the way. He went on a killing spree in the Fulton County Courthouse in Atlanta, Georgia. It was on March 11, 2005. He was on trial for rape when he escaped from custody and then murdered the judge presiding over the trial a court reporter and a sheriff's deputy and later a federal agent. 26 hours after a large-scale manhunt, he was taken into custody. The prosecution charged him with committing 54 crimes during the escape itself. He was found guilty on all counts in 2008. That's a good example of what can happen if security is lax in a courtroom. Now, yes, I've told you that family law matters are the ones that are the most likely to have violence of this type. But again, I also said that it does also happen in criminal matters, but not as much and not as likely. For a lot of reasons, actually. As I said, most criminals know they're going to get caught at some point, and so even though they don't like it, they won't necessarily go out and try to kill someone. They're trying to reduce the amount of time in jail, not increase it. That was an exception for Brian Nichols, who just wanted to kill as part of the escape and kill as many people as he possibly could. It was just one of those cases where they should have treated him a lot more carefully than they did. In any event, that's just something to think about. I mean, this should tell you how important security is in the courthouse. This case should tell us all. This is something similar to this happened in the 1970s in California with some of the terrorist groups that were around during that time. All right, let's look at assembly line justice. Now, we call it assembly line justice because we literally take the one case and the next and the next and the next. We do a little bit of work on it. It's like we're taking a piecemeal approach to it. Certain judges do certain things with a case. So, for instance, you may have an arraignment judge arraigns the defendants. You may have then a law and motion judge that does any of the law and motion work that has to be done before trial. There's a trial judge who's set forth to do the trial. They often are also involved in plea negotiations before the trial. We can sort of put the case into a assembly line where it goes from one judge to the next, to the next, to the next, and or one proceeding to the next, just like an assembly line. And the reason for that is that these criminal cases tend to fit into very specific categories, and they are often very much the same. So, for instance, you have a residential burglary case. They're often investigated the same. We have almost exactly the same kind of evidence that's available, fingerprints, other kinds of things. We have the same police departments, the same prosecutors. We have, basically very similar situations, some more aggravated than others. But what this does is it allows a sort of an assembly line process because the question becomes, is it a provable case? If it isn't, what should we do with it? If it is a very provable case, what's the proper, disposition of the case, short of trial, that kind of thing. And so it allows specialization by each of the players in the process. That includes the judge, the prosecutor, the defense attorneys, the probation departments, and anyone else that's involved in the case. Some of the weaknesses in that when you use an assembly line approach, you fail to consider certain factors that you should be considering more than you are, and certainly if it's kind of a consideration that you just don't see very often, they're often not taken as seriously as they should, and so you get a one-size-fits-all kind of approach that is not always good to some very specialized kind of cases. And that presents a weakness in this system. The strength, of course, is that it gives speed to the process, it gives efficiency to the process, but then again, it doesn't fit every kind of case. Let's look at discretion. Discretion is used every time a decision is made in the courthouse of some sort. The first decision that's being made is whether there's going to be a case at all, and that's for the prosecutor. That's the first decision out there. The prosecutor is also going to make a decision on what position they're going to take on the case, both in terms of proving up the case and on sentencing. That's another discretionary decision being made. You have judges who have also discretion because they can override the prosecutor if they want and offer something less than the prosecutor wants to resolve the case. Because all the prosecutor can actually do is insist on going to trial on every count that they can prove, or that they at least have proven probable cause for. That part they can insist on, but they cannot insist on a specific sentencing. Sentencing is in the discretion of the judge. So, courts have discretion on whether they're going to go along with the prosecutor or they are not going to go along with the prosecutor. The problem with discretion is that you're dealing with the way a particular person feels that day. Maybe they're a little bit under the weather that day, and maybe they're a little too harsh on someone that they should not be quite so harsh on. The old concept of the punishment should fit the crime might kind of go out the window if someone's not feeling so well that day. And that's a bit of a problem, because we don't want unequal justice. We want people to be treated the same, in the sense that we look at every factor and we look at them very judiciously and making the proper decisions. All right, let's look at the courtroom work group. And the courtroom work group is the judge, the prosecutor, and the defense attorney. Sometimes also includes the probation officer if we want to bring them in on it, because they also have a point of view in the case, and they also have often researched the background of the defendant in the case, so they can offer information. But typically the probation officer doesn't do much except make a recommendation. They don't typically insist on anything. They just, again, make recommendations. There is essentially a mutual interdependence among these players. The interdependence happens by the fact that the prosecutor knows that they cannot go to trial on every single case. Defense attorneys sort of know that they can't do that either, and you can definitely be assured that the judge knows they cannot try every single case. There is no physical way that it is possible, even going 24 hours a day, 7 days a week, throughout the year. You would never have enough time to try every single case. So they all are dependent on each other to see if they can resolve cases on mutually agreeable terms. And again, they're 95% successful in doing that, which is actually quite amazing. There's a shared decision-making process. What goes on here, for instance, the prosecutor is, taking a position on what they think is the right amount of sentencing in a case, and it could be based on, maybe the case is not quite so provable, but we'll go down on sentencing as a way to kind of help induce the defendant, who they are still convinced is quite guilty, to go ahead and plead guilty to the case, so that the case can be resolved for something, even so we don't have to take a chance on winning or losing a trial. Or it could be just a very, very strong case, in which case the prosecutor would be less likely to be as generous with their offers of sentencing. But the defense attorneys, they have a different kind of mindset. They know that because of the decisions they have been involved in, where they've gone to trial and they've seen what judges have sentenced people to after a trial, where now it's completely within the discretion of the judge on how they're going to sentence, and there's nothing the defense can do to stop a very, very large sentence against their clients. They get an idea of what is likely to happen if they go to trial. So let's just assume the defense attorney thinks, you know what, I'm pretty sure if you go to trial, you're going to get 12 years. Hey, I can get you 6 years if you plead now. Well, the defense attorney, if it's a very, very good case and they know that the chances of winning that case are near zero, that's a pretty good deal. You could definitely recommend that as a defense attorney. You may, in fact, even twist some arms of your client to get them to take it, because it's so good a deal that they really can't pass that up. And clients often are emotionally involved in this. They're the ones who are going to be spending the next 6 years in prison. They don't always get jumping for joy when they hear about 6 years, but they can be talked into it. And so what happens here is we end up with negotiations going back and forth, much like a contract. And in fact, you do have a contract at the end of this. Is if there's an agreement between the prosecutor and the defense attorney on what the sentencing should be and what counts there should be pleas to guilty, then so long as the judge was willing to go along with it, so we have a contract between all three parties, you got yourself a case resolved through plea negotiations. Okay, let's look at the idea of socialization. And this refers to this idea of It's like learning the ropes, if you know what that means. If you go to a new job, learning the ropes means you learn personalities and procedures. These are things that are not written down. They are often things that are just ways that the things are done in a certain courthouse or courtroom with a specific judge. It can even be, quite specialized depending on what judge we're dealing with. They may insist on things being done in very specific ways. They're not written down anywhere, but they are learned through the socialization process. Your new public defender, you're learning what is expected of you as a member of this courtroom work group. And if you don't comply with it, you're going to end up getting judges complaining to your supervisors about the fact that you're not a very good public defender and why don't you put them somewhere else kind of thing. And you need to learn it, even if you don't like it. You'll usually have to deal with it and try to work in the work group or suffer those consequences. Same thing for prosecutors, same sort of situation. Judges also, by the way, if they're someone who's not doing the right thing in a given situation and their socialization of what they think are the proper ways to deal with things are not to the liking of either the defense attorney or the prosecutor, in California at least, they can be bumped off that trial and off that case, and in fact could be bumped off every single criminal case. And I've actually seen it where public defenders have a policy where in every criminal case they would challenge one particular judge that they thought was unfair to their defendants, and it took that judge out of the criminal court altogether. She went off to doing family law after that, and she was a criminal law attorney, so she did not know what she was doing. In family law, very interesting process. But you better socialize yourself, learn the ropes, and work within the system, or you're going to find yourself again probably being on the outs. Okay, let's talk about normal crimes. The concept involved here is the idea that the vast majority of cases that come into the criminal courts can be categorized into neat categories where we've seen the case before, or very similar cases before, and so we tend to handle them the same exact way. Yes, each case will have its own aggravating and mitigating factors that sort of fine-tune what the eventual decision will be made in terms of plea negotiations and plea offers and so on, but vast majority of them become put into these categories, and we have a pretty good idea what's going to happen in the case and what's the appropriate disposition short of a trial. And this usually means that there is what we call a plea bargain discount. There's been a lot of controversy over whether there's actually a plea bargain discount or whether people are penalized for going to trial, but there's a huge difference in the sentences of people who will plea bargain versus those who go to trial. That's a fact. There is a big difference. You can take almost exactly the same case for both mitigating and aggravating factors, same exact kind of crime, all that sort of thing, and you'll find that those who go to trial get significantly more time. So the question always became, are we actually penalizing people for going to trial, or are we giving a discount to people who save us the problem of going to trial? And in reality, I'm quite convinced that it is a plea bargain discount. It is not a thing where we're penalizing people for going to trial. In any event, that's what this normal crimes is all about. It does create some problems because, again, you're dealing with crimes and you're putting them all into the same category when they may not be that way. There's sort of a spectrum of many different kinds of crimes. For instance, there are some burglaries where they are very minimal, but since residential burglary is a very high crime, it's a strike in California, for instance, you could have one that's very, very mitigated, extremely mitigated, and we won't necessarily give it its due. It's really it's a petty theft case for the most part, because there was nobody around and there was no chance anyone was ever going to get hurt. But in any event, someone just stole some food out of a refrigerator, for instance. Especially if they were hungry, that really starts mitigating things. In any event, we will still treat it as a strike and a heavy crime, and people are likely to go to prison for it. All right, there's also rewards and sanctions. And the rewards and sanctions is a concept by which Those who work well within the courtroom work system will be rewarded. How would they be rewarded? Well, defense attorneys will be able to get better deals. Prosecutors will get better deals. And this is how the judges will make things happen for them. Those who are the mavericks that want to, sort of get in and interfere with this socialization process and with the policies and procedures of the courtroom work group, they're going to see sanctions. They're going to be hard-pressed to get good deals for their clients. If there's defense attorneys, if they're prosecutors, they're going to be very difficult for them to get the kind of sentences that they want in a case. And so there are sanctions. So you can see the process is working. It will work, and it puts pressure on those in the courtroom work group to work together, essentially, to try to resolve these cases on fair terms. There's also variability in the courtroom work groups, and this comes from the fact that there are mavericks out there, both in terms of prosecutors and defense attorneys. So, for instance, when I first became a prosecutor, I was sort of a bit of a maverick. I tended to push for what I thought was the right sentence, and I didn't mind going to trial if I needed to, and judges didn't like that because there were more trials than perhaps there should have been. And so, I even got a nickname, Captain Justice, because, I was always going after the right thing, doing the right thing. And it cost me. It cost me in terms of reputation. Judges were then feeling free to simply disregard me in the courtroom work group and go on and do what they thought was the right thing by their calendar, not my cases. And so I lost influence, and there I got myself a sanction. So there is variability. It does happen, and we'll see that it goes on. All right. Let's look at gender bias. Is that a significant problem in the court system? The issue of gender bias, it usually happens a lot in sex cases, especially, but very often the people who are making decisions and have discretion in the criminal justice system are male, and the victims are often females, and especially in sexual assault cases where there would be less sensitivity to what the victim has gone through by the male discretionary decision makers. There's an idea there's probably some gender bias going on, and I'm sure that it goes on. I've actually had judges talk to me in terms of actually dismissing one of my sex cases because they thought that what was against the law was really shouldn't be against the law. I couldn't even believe it was actually happening to me. And we ended up getting the person on other accounts and got what we wanted. But that kind of situation was my first introduction to the fact that stuff is actually going on. So if you're troubled by using individual reports to make the case for gender bias, what alternative methods would you use if you wanted to actually figure out that whether there is gender bias? How would you even figure this out? How would you know that it's going on? It's a difficult question. We know it's going on as a practical matter. It does go on. The question is, what can you do about it, and how can you measure it so that you can actually deal with it? That's the problem. All right. The problem with the delay. The problem in some jurisdictions, but not others, is that we have large delays in the trying and resolving of cases, and that presents real problems to to the victims, to the witnesses, to people involved in the case. Mostly the victims, because they're the ones who want to see justice, and they're not getting it, and it can take sometimes years. Especially the more serious the case, the more likely it's going to take a very long time. Not that it has to, because if the defendants insisted on their speedy trial rights, things would happen within a couple of months, and even in a felony trial, as we saw in the O.J. Simpson criminal case. But some of the consequences of delays is it erodes public confidence in the judicial process. It can violate the Sixth Amendment right to speedy trial, but if it does, by the way, then defense attorneys will properly bring the motions to dismiss the case on the basis of a violation of the Sixth Amendment, and that's the consequence of violating the Sixth Amendment. So it doesn't actually, you may see violations of it, but you're going to get the case dismissed if you do. In fact, I've actually seen it where the clerk forgot to call in a jury on the last day for a criminal case felony criminal case, and the judge actually ordered the bailiff to go over to the mall and pick out, 12 citizens and bring them in because we're going to set up a jury. Involuntarily bring these people in who just happen to be in the mall shopping. That just show you how important it was that we get that thing tried, because there was no waiver of the Sixth Amendment right to speedy trial. Let's look at some of the cost of delays. It, of course, forces defendants to enter detrimental plea bargains because they sometimes just get tired of being in custody. It has actually happened that people were in custody for felony cases longer than we could sentence them to for the worst case scenario of a conviction. What are you going to do in a situation like that? Well, it's kind of interesting. If they keep waiving time, they'll end up spending more time in custody than they would if they were to plead guilty. Kind of a problem. Also, you can force prosecutors to offer lenient agreements because, frankly, they're starting to lose evidence over time. People's memories start kind of going away, and they know it, and they get into trouble that way. And sometimes defendants will skip court appearances, and we have to go out and try to find them, and sometimes we can't. That's some of the problems that go on here. Let's look at some of the case processing standards out there. Non-jury civil cases, most at least standards are that we should have them tried within 12 months. Jury trials for civil typically within 18 months. Criminal cases, felonies should be within 180 days, misdemeanors within 90 days. And the ABA processing standards are about the same, are very similar, slightly higher. But these are what we think are normal processes. And then in most cases, we'll be able to stick to this, but only if we can deal out 95% of the cases in criminal matters. And juveniles, we deal with detention hearings within 24 hours of being arrested, and a few other things. For domestic cases that are uncontested, well, we want to resolve within 3 months. If they're contested, within 6 months. And the ABA standards are slightly different, but not much different. All right, felony disposition times in 4 different courts. You can see here that in court number 1, for instance, we had 14% of the cases that were resolved within 180 days. Another was 78%. Another was 43%. Some was 88%. All depends often on how good the judge is at dealing with cases, how good the courtroom work group is, how many cases we have versus how many judges, and so on. So it's really difficult to understand exactly how that's going to work out in any given court system. All right, let's think about this case processing times. Let's consider the courtroom caseload in processing cases, and let's research the average time for cases within your area. How long or how short do you think cases are? I bet you if you called up your court administrator in your local area, they would tell you, because they know what those stats are. That is very important to a court administrator, because those things are something that the courtroom and the courthouse is judged on by the judicial council within that area, and whether or not they are doing a good job as to how fast they're getting their cases resolved. Okay, yeah, and then is this all fair to the citizens in terms of what we actually find? So if you ever have a chance to do that, we can easily discuss that. It would be a good thing to discuss. Let's look on law on the books approach to court delay. First, we know there's speedy trial laws, both federal and state statutes, as well as the constitutions require specific, although the Constitution doesn't require a specific time, they only require a speedy trial. It's statutes that actually specify the amount of time, state and federal, before a trial has to come into a trial. And trial is defined as actually swearing in the jury, and that's when the trial starts. And then the speedy trial has to continue continuously thereafter. You can't just take a 3-year hiatus in the middle. You have to start the trial and then continue it day to day until you're done. So there's limits of speedy trial laws, but what the law on the books process is, you must file. And by the way, in California, you have 60 days from the filing of the information, which is after your probable cause hearing, to go to trial. That's the law on the books. Does it actually happen? No way. Absolutely no way. So let's look at the there's actually the Barker versus Wingo case. We'll go through that here in just a minute, but let's look at the law on the action approach. Um, and we deal with the law and the action approach. We're dealing with, we have lots of variability in the courtroom work groups, and we have efforts at coordinating the whole process of many different trials, many different matters. There's case scheduling that goes on. There is very practical ways that we have to deal with having more cases than we can possibly try in every courthouse in the jurisdiction. We basically do our best to try to resolve as many cases as can without trial, because we know trials take a long time and they only really resolve one case. So with that in mind, the law and action approach is, let's just practically deal with this in some way that will make it all happen. Okay, let's look at this Barker versus Wingo case. In this case, it was a situation where Barker was one of two different defendants in a very heinous kind of murder of an elderly couple. And Manning was the other defendant, and he was someone that the prosecution had a good case on, and they wanted Manning to testify against Barker, but you can't have that happening when they're both in the same trial. Why? Because Manning has a right against self-incrimination, so you can't call him as a witness in the case against the other defendant. You could, if you could get Manning to a trial and get him convicted, then Manning couldn't refuse to testify at the Barker trial. And we could get Barker through Manning's testimony if we can get Manning tried first. Well, it happened to be that Barker was pretty cooperative through 12 continuances over 10 months, and there was lots of different problems in getting Manning to trial. Finally, they did get Manning to trial, and then there were more continuances thereafter because the investigating officer became ill, and there were several continuances for that. There were a lot of other problems going on trying to get Barker to trial. It finally came to be that the judge says, if you don't get this guy to trial, this Barker guy to trial, like at the next date, I'm going to dismiss the case and it's going to be gone forever. Well, they finally got it actually going. They finally got him and they had Manning actually testify, and they got Barker. But we had just a tremendous amount of delays that, lucky for the prosecution that Barker was willing to go along with it. I would never have gone along with it because I could force him to let my client out and dismiss the case because they couldn't try it. But that they went along with it for no good reasons, frankly. It's a practical matter. In any event, you can see that there's problems with this continuance and lack of speedy trials being done appropriately. And this is one of them. Someone's rights were being sort of tread on, and it was just we just barely got him to trial, and only because he was willing to go along with things did that actually go the way it should. In any event, let's go on to legal ethics. Legal ethics is very important for many different reasons, especially during the adversarial system. We expect fair trials, and we cannot have fair trials unless both sides are acting ethically. And that is that they're doing first what they're legally required to do, but then also what is right and fair and just under the circumstances, because the criminal courts are all about justice, doing the right thing in a criminal context. We're dealing with people's lives often, their incarceration and so on. So lawyers are not allowed to mislead the court, for instance, nor can they knowingly allow witnesses for their side to perjure themselves. The highest court each state is responsible for enforcing these ethical guidelines, and so there are limits to what attorneys can do, but often they will not just skirt the edge of these ethics, but sometimes actually break them because they're more interested in winning the case than they are in doing justice under the law, and that becomes a real problem. So. So you think about maybe going out and researching a recent case. You'll find more ethical violations by prosecutors you'll see in published cases than you will for defense attorneys. But you'll find them often where prosecutors intentionally don't disclose exculpatory evidence to the defense, and especially in murder cases. And people sometimes are put to death or could have been put to death and have been put in prisons for many, many years as a result. These are very bad things. These are things that corrupt the entire system. So get yourself a case and read it and see what kind of bad things can happen when either prosecutor or defense ends up doing something that is unethical in the pushing or defending against a criminal case. All right. All right, that's it for Chapter 5. If you have any questions, feel free to give me a call or email me, and I'll be more than glad to help.